negligence in the law of tort? Negligence in the law of tort refers to the failure of performing the standard duty of care, thus breaching essential legal obligations, as one should expect from a reasonable man who would likely foresee the effects and potential implications of his actions, be it either a positive action or the omission of an action. Nonetheless, we are here to discuss whether the tort of negligence is still relevant in today's day and age, or whether there is a need to revise or rethink our position in terms of understanding and applying negligence in tort. My team and I will walk you through the principles created for the tort of negligence that is particularly ingrained into English law. As with any discussion, one should start at the root of the issue, and the case that is often deemed as the forefather of modern law of tort is the case of Donahue and Stevenson. By dissecting the case down to its essence, in the case of Donahue and Stevenson, the claimant found a decomposing snail in her ginger beer. However, due to a lack of privity of contract with the cafe owner, she was unable to take action. Thus, she decided to take action against the manufacturer itself, as a result of this case, this gave rise to the neighbor principle as established by Lord Atkin, thus establishing proximity and foreseeability as factors in determining duty of care. Established by Lord Atkin has also extended its roots into the realms of the Malaysian legal system. As for Malaysia, there are no specific or particular statutes that govern tort negligence pursuant to Section 3 of the Civil Law Act of 1956. The neighbor principle has been cited in numerous Malaysian cases, an example of which would be the case of Satu and Hawthornden Rubber Estate, in which 19 heads of cattle belonging to the plaintiff had wandered onto the defendant's land. Unfortunately, the defendant had sprayed his land with sodium arsenite a few days prior, and as a result, all the cattle died of poisoning. The plaintiff then sued the defendant, claiming there was a breach of the neighbor principle. However, in order to establish that fact, it must be established that the defendant must have foreseen that the plaintiff's cattle, and not anyone else's cattle, would have likely wandered onto his land. And since it was not reasonably foreseeable by the defendant within an equitable scope, he was not deemed liable and thus did not provide any duty of care to the plaintiff. Thus, with the application of such a concept, the main question that arises is whether tort negligence is still relevant in today's world, which must be done through understanding and identifying the ambits of negligence and tort. I will now pass the floor to Chris for further elaboration.
The tort of negligence is still relevant today because it is the only way to hold people accountable for when they have breached their moral obligation or duty recognized under the law. As such, regardless of the time period, the tort of negligence is an outlet where it will impose accountabilities to the responsible parties. Hence, it creates an umbrella to protect individuals from possible harm and damages that were rendered by negligence. This protection can be observed in the advent of negligence standard. This can be seen in numerous instances, such as the principle of duty of care and the principle of duty of negligence. To further the understand of the matter, we must delve into the core elements of negligence itself. The first element that is within the parameters of the tort of negligence would be the issue of duty of care. What is it, you may ask? Duty of care arises when the law acknowledges that there is a relationship between two parties. So the rendered an obligation to act in a certain manner to another person. Drivers on the road would be a good example to demonstrate the element of duty of care. All drivers have to exercise the duty of care towards other drivers, cyclists, pedestrians who all share the roadways. They are all required to abide by the traffic signals and the laws. They also must refrain from causing unreasonable damages to others. Thus, in the case Nettleship and Weston, a learner driver went out for her first ever lesson, supervised by her friend. She crashed the car into a lamppost, and her friend got injured. The friend sued the driver for damages and won. The court felt that the driver should be liable for his actions when comparing his position to another driver. To further elucidate this idea of holding another person accountable for their own actions, we can see that the courts have also held individuals liable if there is negligence involved on the part of the individuals themselves. Often we would connect the dots between the actions and the consequential damages pursuant to the re-polymus principle. Yet, we can see another side of the coin where certain cases have shown that the courts will be equitable in determining that the rightful owner of these responsibilities. As the courts still apply the principles of morality, courts try to fairly determine whether there is a duty of care in the first place. Was there a negligence on the omissions of the actions done by the victim? In the case Froome and Butcher, the plaintiff has suffered multiple injuries. However, the court deemed that the broken finger cannot be claimed due to contributory negligence. This would apply in the case where the plaintiff could have prevented injuries if the plaintiff wore his seatbelt. This is considered a contributory negligence which caused a break in causation link between the action per se to the consequential damages. Another case that exemplifies the notion of determining the duty of care is Smith and Finch, where a plaintiff was a cyclist who was not wearing a helmet, and when he got into an accident with the defendant, the court held that the duty for the motorist to wear a helmet is imposed on cyclists as well. The head injury is also due to contributory negligence on the plaintiff. This shows that the courts properly determined the duty of care, as the courts did show the considerations on the grounds that there is shared liabilities between both parties. In the case of Fairchild and Glenhaven Funeral Services, the employers sought a contribution of compensation for the plaintiff for other employers under the Civil Liability Contribution Act 1978, Section 1. However, it was brought to question that what could have been a reasonable cause of action by the court if the plaintiff also exposed himself to asbestos during self-employment. This question was answered in 2004 in the case of Barker and St. Gobain Pipelines. Fairchild principle was applied in the Barker's case to hold employers liable. However, the plaintiff was also expected to take responsibility on the basis of contributory negligence. These cases show that although it's accurate to impose standard of care on the relevant parties, the courts have also displayed sufficient care by being equitable in the imposing of the duty of care. This exemplifies that the tort of negligence is still relevant in the current society. There are also different variations to the concept, particularly involving different demographics. The courts will also delve into a maturity of the parties themselves, and then there are limitations and diminished standard of care to these parties. In the case of Mullen and Richards, the claimant and the defendants, who were 15 years old schoolgirls, were fencing with plastic rulers. And throughout a lesson, the plastic ruler snapped. A piece flew into the claimant's eye. This resulted in the claimant losing her sight. It should be noted, however, that the game itself was not banned in school. However, the judges ruled that the 15-year-old, unlike an adult, could not be expected to foresee the risk of her behavior. Some degree of her irresponsibility is expected whilst children play together. Thus, this further highlights the notion which states that the court tries to fairly determine whether there is a duty of care in the first place. Malaysian's court takes a similar stance to the English position. The court's fairness in determining the duty of care further strengthens the stance of negligence is still relevant in some solving disputes in today's time.
The second element of negligence is the breach of duty of care. This refers to the scenario when an individual or an entity, such as a business or a government agency, fails to take reasonable measures to ensure duty of care. The dynamics of this relationship today are quite similar to the past, which reinforces the idea that there is no need to reevaluate the applications of negligence in tort. The consistency of the approaches in the tort of negligence do prove that the tort of negligence is still applicable in today's relationship between the employers and the employee. The employers are expected to exercise substantial care to the employees. This principle can be seen in McGee and National and Coal Board in 1972 and was carried forward to a relatively more recent case of Fairchild versus Glenhaven Funeral Services in 2002. Furthermore, the effort of establishing a breach of duty of care can be seen in the cases of Bolton and Stone and Miller and Jackson. Despite both cases having similar premises on the surface, there are key differences in Bolton and Stone. The plaintiff was hit by a cricket ball. The ball itself was hit out of a cricket court, which then hit the claimant, who at the time was standing on the pavement outside her house. It was inferred that the ball traveled about 100 yards to the edge of the field, which was notably covered by a 7-foot wall. It should be noted, such an occurrence was quite rare, as it had happened only about 6 times in 30 years. Due to the circumstances, it was deemed that the damage was rather remote. On the other hand, in the case of Miller and Jackson, cricket balls were hit out of the fence of the cricket field at the rate of about 6 to 9 times per season. This, unfortunately, caused damage to the plaintiff's property. Although there was a high fence surrounding the whole field, the distance between the pitch and the fence was rather short. Where the ball was hit, it was held that the risk of the injury to the plaintiff was high, and the defendant was liable each time the cricket ball damaged the plaintiff's property. The precautionary measures adopted by the defendant were deemed insufficient to overcome the risk of injury to the plaintiff. Both cases were different due to the foreseeability of the positive actions and the omission of certain actions which led to the consequential damages. As such, it is through these methods, as observed in the cases in which breach of duty of care can be established. This allows the courts to make the correct decision to ensure that the appropriate measures are taken. Therefore, it is indeed apparent that tort of negligence is still relevant in today's world. The third element of negligence is causation. There are two distinct but closely related components of causation: actual cause and proximate cause. Actual cause, also known as cause in fact, exists when an individual's loss is directly related to the defendant's action. Proximate cause exists when the type of extent of the injured person's injuries were reasonably related to the breach of duty of care. Some examples of causation would include a manager of a grocery store who witnesses a store employee spill cooking oil on the tile floor in the condiments aisle. Neither the manager nor any of her employees attempt to clean up the spill in a timely manner. As a result, an elderly customer slips on the spilled oil, breaking her hip. If it were not due to the apparent failure of both the grocery store managers and her employees, it would be sufficient to say that the elderly customer would not be in the aforementioned situation. Therefore, a broken hip is indeed connected to their breach of duty of care. As such, it is through the element of causation in which negligence can be established, thus establishing its importance in tort law. The fourth element of negligence is damages. The injured person must have suffered an injury that can be remedied by financial damages, which is the legal term for monetary compensation. If it were not for negligence in tort, even today, there would have been no way to hold the tortfeasor liable, nor would there be a way to provide compensation for the victim, as negligence is concerned with compensating people who have suffered damages as a result of others' negligence. In hindsight, the aforementioned principles of negligence are still applicable and relevant in today's society.
The second argument in favor of the aforementioned topic is the notion that the tort of negligence is still undergoing development to address the issue of negligence. The principles are evolving to adapt to the needs of the current society. Hence, the direction in which the courts have undertaken is still relevant in this contemporary world because the courts will expand the principles in the tort of negligence. As previously mentioned, a major concern regarding tort of negligence in today's world is whether it can be applied in a modern context. It should be noted that it is an ever-changing concept that has constantly evolved to meet the requirements deemed necessary at the point of its creation. This can be seen in the shift between the neighbor principle in the case of Donahue and Stephenson to Ann's test followed by Caparo's test. As such, there are additional desiderae to determine the existence of the duty of care. To further illustrate this point, I'm going to delve into the cases to support my argument. We have known that the neighbor principle and how it was the foundation that allowed the tort of negligence to build on it. We can see that there is an attempt prior to the neighbor principle, which is in the case of Heaven and Pender, in trying to develop principles to impose duty of care. Therefore, we can see that the courts are adapting to the changing demands of the societies. Later on, the courts expanded on the precepts of tort of negligence via the case of Anne versus Marsden London Borough. In the case, Lord Wilberforce proposed a development to include a novel approach to establish the principle where the courts will examine whether there are policies that limit the scope and the responsibilities of the party involved. There was a pressure to adapt to the new circumstances, a new type of defendants, a new type of damages, and a new type of legal duty being imposed. the two-pronged test established enhances the effectiveness and the precepts of the tort of negligence. Now, we are going to move on to the ends test, which is superseded by the second case, which is Caparo versus Dixon. In this case, the shareholders in Caparo Industries made an effort to purchase more shares from a company, Fidelity plc. They then proceeded to initiate a takeover from the aforementioned company. This was done after studying the audited accounts that were prepared by the defendant. However, there is a discovered that the accounts were inaccurate. They proceeded to bring actions against the auditors. This was done as they claimed that they relied on the accounts which showed a surplus rather than a deficit. Thus the question arose whether the defendant was liable in the light of negligence of the preparation. The main result of this case was the application of the three-pronged approaches in an effort to establish negligence. The three tests included 3 points of considerations, which includes: first, foreseeability; second, proximity of the relationship; and thirdly, whether it is fair and equitable to impose duty of care. To further establish the prominence of this case, it was been cited as other cases as well. An example for this would be AK versus Central and Northwest London Mental Health NHS Trust, the Royal Borough of Kynaston and Chelsea. In this case, this is not deemed fair to state that the defendant had a duty of care to the claimant to provide after-care services. This was done in reference to the case of Caparo Industries, which allowed the courts to test for the existence of duty of care. In addition to the Malaysian position, which is also similar to the English position, as seen in the case of Loh Kwan Moy and others versus Ramli bin Jamil and the government of Malaysia. In this case, there was a raid of an alleged gambling on a fishing boat. This caused the fishermen to jump into the river in an attempt to escape from the police raid. The police shouted at them to return to the shores to be arrested. The deceased was noticed by a fishing boat and the deceased was clearly struggling. The policeman in charge screamed at the policeman in the boat, trying not to interfere unless he wished to be arrested. As a result, the courts found that the policeman to be liable because the police deprived the deceased from necessary help that could potentially save his life. It was stated that the police could have foreseen the possible outcome of not saving the deceased from the river. Not only that, there is also a duty of care imposed on the position of the police because the police should have made the necessary actions to save the deceased. And due to all their negligence, the police had breached that obligation. Therefore, it can be inferred that the tort of negligence is indeed still relevant as the courts develop principles that are necessary to address the issues in the society. This shows that the court will be relevant to the current societies and they will adapt to the changing societal norms.
Another major concern regarding tort of negligence is in its rather specific definition. As such, some may be concerned whether it may be able to cover any potential legal loopholes. However, tort of negligence is indeed still relevant because the courts will draw and incept upon other concepts to supplement any potential gaps in its definition. This can be seen in numerous instances. Examples of this would include the but-for test, the reasonable man's test, the intervening act, and remoteness. It is therefore vital to apply said concepts within the tort of negligence itself, depending on the context of the situation. To further illustrate this point, the reasonable man's test will be analyzed. The reasonable man's test is an objective test in which the behavior of the defendant is compared to that of an ordinary person in ordinary circumstances. This test was used in the case of Glasgow Court and Muir, in which the defendant accidentally spilled hot tea over children. However, the courts held that the action per se had limited foreseeability, thus the defendant was not liable. However, it should be noted that the reasonable man's test alone may not be applicable in all situations. Thus, the courts will identify the relevant skills and the state of mind of the parties in order to establish the presence of negligence. This can be seen in the case of Mansfield and Wiedebeeks, in which the defendant went into a hypoglycemic shock due to a lack of glucose while driving on the road. He was unaware of the situation and got into a collision with the plaintiff. The courts held that at the moment of collision, there was no reasonable foreseeability where the defendant would have been able to anticipate his circumstances. Thus, he was not liable for the damages. As such, there's a slight difference in applying the reasonable man's test because when the defendant is compared to his peers, it can certainly be concluded that there would have been clear negligence at play. Conversely, the courts took into account the fact that there are indeed variations to circumstances. The reasonable man's test in this case failed to explain the situations that negate rational thoughts and uncommon situations. However, if one test does fail, another should be done in its place to ensure a fair judgment. Keeping this in mind, it is safe to conclude that the tort of negligence is indeed still relevant in today's ever-changing environment.
On the contrary, it is argued that there is a need to revise the definition and application of said definition of tort of negligence. The traditional schools of thought may not befit the characteristics of current societies. Therefore, the very foundation of tort of negligence has been put into question, revealing a somewhat ambiguous nature. This can be observed in hindsight because once the case of the Caparo test was decided, it seemingly created a paradigm shift that sent ripples throughout tort law. Some may even claim that it may render judicial decisions questionable. This caused the judgments by the court to be seemingly confusing in nature, as it has been noted that the results of tort cases have varied over time without adherence to the root principle. This may lead to confusion. To understand this better, we can look into the case of Bowen and Burnett Hospital Management Committee. In this case, the plaintiff consented to undergo electroconvulsive therapy and he was not warned of the risks of fracture, and obviously he fractured pelvic bones on each side. This case was momentous as the courts held that the doctor was not liable as he was only performing what was concurred by medical profession. In addition to this, the balance of probabilities further cements this argument. What is balance of probabilities in the first place? The balance of probabilities is burden of proof in a civil trial. It is also known as preponderance of evidence. The common distinction is made with balance of proof in a criminal trial, which is beyond a reasonable doubt. In a civil trial, one party's case needs to only be more probable than the others. So the question the contemporary world now faces today is this: are percentages an effective tool in determining and influencing judgment? The case that we are looking into is Greg and Scott. So in this case, the claimant, Greg, he noticed an unusual lump underneath his arm and he subsequently sought a medical opinion regarding this. The doctor negligently and incorrectly diagnosed the lump as benign, even though the lump was a malignant cancer which was not discovered for a further 9 months, leading in a sizable delay of his surgery. During this course of period, the lump had grown considerably and his condition had worsened. Medical testimony suggested that had the treatment been originally done and the lump had been correctly diagnosed at the plaintiff's original appointment, the plaintiff had a 42% chance of survival. However, his chances of survival had decreased to a 25%. And not only this, the options that were available, options for treatment to the plaintiff, were also cut down severely due to his condition. Keeping this case in mind, we're forced to wonder, was the decision suitable? And subsequently, can we trust the concept of tort of negligence to assist us in the world today? And even so, do we need to revise the definition and application of tort of negligence to fit today's standards? Further proof the notion that tort of negligence is no longer applicable in a modern context, one should view it through a somewhat recent lens on mental illness. As we step into the 21st century, awareness of mental illness has risen, and with it comes a host of questions regarding the law. The chief concern regarding the issue would be this: whether tort of negligence, being a rather old concept, could be applied to issues regarding mental illness. Even though there's a separate entity responsible for handling issues regarding mental illness, psychiatric injury is more relevant in textbooks as opposed to real life. Despite the rise in awareness regarding the issue, cases involving mental illness are usually deemed as being less vital in the bigger picture. As such, one should rightly question the validity of the concept and ultimately cannot be used to them when should the need arise. For example, illnesses related to stress are not recognized under the industrial scheme. If someone who would suffer from mental illness cannot make any claims due to rigidity of the current system, then why is such a system in practice? In other words, tort of negligence in its current form is not suited to tackle cases of this nature, therefore further cementing the notion that it is no longer applicable.
All things considered, it is safe to conclude that even though there are a few exceptional cases, such as Gregg and Scott and Smith and Baker, that tend to make us question the relevance of negligence in tort, it still remains widely significant in society. As if it were not for negligence in tort, even today, there would be no way to hold the tortfeasor liable for negligence or to provide compensation for the victim. And that is all I have to say. Thank you for listening.